Welcome to Case Note Friday. My name's Fadan. I'm a family law solicitor practicing in Sydney, Australia, and today I'm going to talk to you about a property settlement case which involved Karen and Steve. The case is called Stewick, and it's a property settlement case involving overcapitalisation, and it's interesting. So let's get into it. This is a story of a 12-year relationship. Both Steve and Karen got together in 2010 and were together for a total of 12 years. They did marry in November 2017, having lived together since 2010. Now, when they got together, all things were not equal. Karen came into the relationship with about $27,000 worth of assets, which was a car and a little bit of superannuation. And Steve came to the relationship with about $1.5 million of assets. He was 9 years older, so he had more wealth. They both worked in the military, and as a result of that, they were very supportive of each other's careers. There was no children between them. So all things weren't equal coming in because, as I said, Steve had $1.5 million in assets and she had about $27,000. So over the 12 years, they accumulate assets together. In particular, they have a house. We call this the former matrimonial home. They buy this house together. Steve sells the assets that he had before, and which assists them in buying the house and renovating the house. This one big house Steve absolutely loved. And when they broke up, Steve continued to live in the house and Karen moved away. So after the 12 years, Karen wants a property settlement. She wants her share of the house paid out to her. Now, of course, remember how all things weren't equal because he came in with more. Now, in Australia, when we go through a property settlement, we go through a 5-stage process. This is the process lawyers go through when they give advice to clients, and it's the same process a judge would go through if they were to give a judgment in a family law decision. Exactly the same process. I'll take you through it quickly. The first stage is we need to decide whether anything needs to be done. That's based on a High Court case called Stanford. In this case, something does need to be done because we need to pay out Karen her share. Secondly, we have a look at the balance sheet. What is there to divide between the parties? In this case, as at the date of the trial, the assets were $2.78 million. They were together for 12 years. 2.78 is the amount we've got to divide. That's what our balance sheet said at stage 2. Stage 3, we have a look at, of the $2.78 million, where did it come from? Who contributed what? We look at financial, we look at non-financial, direct and indirect contributions over the course of their relationship and since separation. Now, clearly, Steve is ahead at contributions. How do we know that? Because remember, he had more coming in. He had the 1.5 and she had that $27,000. So at the trial, the court considered all of the evidence and said, well, Steve does have greater contributions because he came in with more. So the trial judge said at the contribution stage, he's going to award Steve 63% and Karen 37%. Now, the 63% to him was $1.78 million. Now, remembering that he had 1.5 earlier, but anyway, we'll come back to that. So that's what the trial judge says. 12-year relationship, I give Steve 63% based on contributions. But of course, there's another step. The next step is we look at the future financial needs of the parties. Are all things equal looking into the future? Well, as I said, they both worked in the military. However, Steve had greater future financial needs. That's what the judge said. What were those needs? Well, her father had passed away and she had an inheritance coming to her. This happened after separation. The inheritance was $455,000 that she was going to get. So that's an extra benefit that Karen has that Steve does not. So that was taken into account. In addition, Steve had some issues, some psychological and physical injuries, which would impact his ability to earn an income into the future as high as hers. So the fact that he would have a lesser income was taken into account. And he, of course, is older. He was 46 and she was 37. So the judge took those factors into account and gave Steve an adjustment of 5% for his greater future financial needs. Let me show you what the trial judge said. As I said, at the contribution stage, then he assessed contributions at 63% in favour of the respondent. That's the husband, so which amounted to about $1.78 million. And then he got this adjustment of 5% for the fact that she had this inheritance coming to her, $455,000. I forgot she'd repartnered as well. She had a new man. So because she had a new partner, which means she had someone who can share her expenses, whereas he didn't have that person. And he also had the physical and psychological injuries. So all of that meant that he got an adjustment of 5% in his favour. Remembering he was at 63%, so that meant he ended up getting 68%. Now, when the decision came out, Karen wasn't happy that Steve was getting 68%. She thought that decision was bullshit. Why does he get 68%? She said to herself. This doesn't seem fair. Now, the reason that she argued that is because she said that their wonderful house had been improved. However, he had overcapitalised. That $1.5 million of assets he had in the start, he disposed of that and put it into this giant, big, former matrimonial dream house of theirs. He just poured lots of money into this house. However, it wasn't reflected in the value. That is, there wasn't a dollar for dollar correlation between what he put in and what it was worth at the trial. So she's tried to argue that that was wastage. And because of that, she thought she had a ground of appeal. So she appealed the decision and said, I don't agree with that decision. I'm appealing because I think the court got it wrong because of that overcapitalisation. So she only had the one ground of appeal. This is her ground of appeal. The trial judge assessment of contributions is both outside a reasonable exercise of discretion and contrary to the evidence. That's because she was going to say the overcapitalisation of the Lemon House. She said because of his poor decisions, that is pouring all that money into the house, that the court should have taken that into account and not given him a credit for the $1.5 million, not all of it anyway, because she said it amounted to wastage. Now, the husband himself, when he was in the witness box at the trial, admitted that he'd overcapitalised to the tune of about $500,000. However, the wife said that that was understated and it was way more than $500,000. She said that the wastage was in fact more like $1.65 million. But her rationale and her math didn't quite make sense because when they separated, December 2021, the property, that's the giant Lemon House, had a value of 1.225. But by the time they went to trial, the property was worth more. It was worth 1.525. So that's around $900,000 greater than what they'd paid for it, which was $626,000. So the Court of Appeal goes through this simplistic maths to basically say, look, she's overstating it. He conceded it was about $500,000, and on this math, it was more like $450,000. So it doesn't matter. They had decided that they were going to build and renovate this beautiful dream house together, and they were going to put money in. It was a decision they made jointly when they were together. After they separated, he continued to work on the property to create the dream house, even though they'd separated. So remember that family law is an area of discretion. That is, the trial judge has a lot of discretion because they're the ones that hear the evidence and hear the witnesses in the witness box. On appeal, they just go off the transcripts. You don't get another hearing. So the appeals judge thought about it and said, you know what, I think this decision was within the trial judge's discretion. He did take all the factors into account, including the overcapitalisation. Let's remember those steps. We've got Stanford, whether or not anything needs to be done, balance sheet contributions, future financial needs, and the last ground is justice and equity. And let's not forget, of this case, the husband came in with $1.5 million. He walked away with about $1.89 million, an increase of about $390,000. So in a way, he'd kind of gone backwards. It was a 12-year relationship. Over that, he'd only increased his assets by $390,000. Whereas the wife came in with $27,000 and she was getting $900,000 as a result of this 12-year relationship, an increase of $872,000. So you know what, Karen? It's pretty fucking good for you. What are you complaining about? Why did you appeal this decision? Seems right on the money to me. I would have thought it was a 70-30. It was almost a 70-30. He did a little bit worse than that. But she's the one who appealed, who thought the whole thing was really unfair. And this whole idea of the overcapitalisation. The court isn't going to interfere with decisions couples make when they're together about their lifestyle and the way they want to renovate their house or how much money they want to put into the house. The house had gone up in value and they had overcapitalised. But so what? It's a decision that they'd made together. So at the end of the day, I think the decision was right. And because she lost, she had to pay his costs of the appeal. They were appeal dismissed. He claimed costs of nearly $23,000 and the court fixed it in $17,500. So of the $900,000 she got, it was less the cost she had to reimburse him. So you know what? I think we say, suck it, Karen. That was a terrible decision to appeal. I don't know who advised you to do that, but perhaps it was a mistake. So Steve continues to live in his wonderful overcapitalised Lemon House.